In this video, we'll look at the European Union's regulation on prohibiting products made with forced labor on the Union market, which is also known as the EU Forced Labor Regulation. This legislation was adopted on the 19th of November 2024 to reinforce the EU's commitment to human rights and ethical trade practices, and will take effect in 2027. We'll look at some key takeaways from the regulation, how it will be implemented, and its relationship to the EU's Corporate Sustainability Due Diligence Directive. The regulation defines forced labor by referencing ILO Conventions No. 29 and No. 105, which characterize forced or compulsory labor as all work or service which is exacted from any person under the menace of any penalty, and includes forced or compulsory labor of children as well as forced or compulsory labor imposed by the authorities of the state. We'll cover these 6 key takeaways from the regulation. A risk-based approach, the database of forced labor risk areas, enforcement outcomes, human rights due diligence assessment, the relationship with the CSDDD, and a comparison with the United States Uyghur Forced Labor Prevention Act. The ban of products made with forced labor is founded on a risk-based approach. Economic operators are scrutinized only if substantial concerns, based on reasonable and verifiable evidence, suggest forced labor involvement. The European Commission will create a database of forced labor risk areas or products to support the work of competent authorities in assessing possible violations of the regulation. Products found to have been made with forced labor can be removed from the EU market, seized, withheld, recycled, or donated. In-scope businesses must establish robust supply chain monitoring systems to ensure compliance and demonstrate their due diligence efforts regarding forced labor. This regulation complements the Corporate Sustainability Due Diligence Directive, CSDDD. Implementing due diligence mandated under the CSDDD is crucial to comply with the forced labor regulation. The United States Uyghur Forced Labor Prevention Act and EU's Forced Labor Regulation both address the issue of forced labor. In the US, the Uyghur Forced Labor Prevention Act, which was signed in 2021, sets a precedent as the only domestic legislation specifically targeting state-imposed forced labor and products originating from the Xinjiang Autonomous Uyghur Region in China. The US Act reinforces existing prohibitions outlined in Section 307 of the Tariff Act, 1930, which bans the import of goods, wares, articles, and merchandise mined, produced or manufactured wholly or in part by forced labor into the US. The US Act is based on a rebuttable presumption that all goods mined, produced or manufactured in Xinjiang or by entities operating in Xinjiang or by any entity on the Act's entity list are presumed to be made with Uyghur forced labor and prohibited from entering the US. The US Customs and Border Protection then detains goods that are potentially tied with Uyghur forced labor, until importers can prove otherwise. This guilty until proven innocent structure demands clear proof of forced labor free from importers before goods are allowed into the US market, placing a substantial compliance burden on companies. In contrast, the EU's Investigate First approach relies on national authorities to examine products post-entry, allowing for flexibility but potentially slower responses. This significant difference means that under the EU regulation, products can enter and circulate within the EU market while authorities conduct risk-based assessments rather than facing immediate detention. Investigations by relevant authorities will be the main mechanism for enforcing the regulation. Suspected breaches will be subject to a preliminary and formal investigation. Suspected breaches will be assessed following a risk-based approach, based on the following criteria: the scale and severity of the suspected forced labor including potential involvement of state authorities in imposing such labor, the quantity or volume of products placed or made available in the EU, the share of the part of the product likely to be made with forced labor in the final product, and the proximity of economic operators to the suspected forced labor risks in their supply chain, and their leverage to address such risks. During the preliminary investigation phase, the competent authority assesses the likelihood of a product being made with forced labor. In this phase, authorities shall further request information from the company and other product suppliers about their actions to identify, prevent, mitigate or bring to an end or remediate risks of forced labor in relation to the products being assessed. They may also review and request other information including submissions from individuals or organizations, input from other authorities, risk indicators, and the database. Companies will have 30 days to respond to a preliminary investigation. If competent authorities, based on objective and verifiable information, find substantiated concerns to suspect that products were made with forced labor, they will initiate a formal investigation. Companies will have 30 to 60 days to provide requested information. Authorities may also conduct field inspections if needed. Failure to comply within the timeframe could result in decisions being made based solely on available information. Authorities will prioritize companies closest to where forced labor is suspected, considering factors such as size, resources, product volume, and the scale of the suspected issue. If the investigation leads to the determination that the products were made with forced labor, the authority will adopt a decision which may contain the following: prohibition to place, make available and export the products concerned, order the relevant economic operators to withdraw the products already placed or made available on the market, including through online platforms, and order the relevant economic operators to dispose of the respective products or parts thereof in accordance with national law consistent with union law. If the competent authority is unable to ascertain whether a violation has occurred, then the investigation will be closed. However, the authority may launch another investigation into the same product and same economic operators if new evidence becomes available. If the economic operator fails to comply with the decision, penalties for non-compliance will be applied in accordance with the regulations set forth by EU member states within 2 years of the regulation's implementation. As the EU continues to strengthen its regulatory framework around corporate responsibility, the Forced Labor Regulations complements the Corporate Sustainability Due Diligence Directive, CSDDD, that was adopted on the 24th of April, 2024. While the Forced Labor Regulation takes a product-based approach, the CSDDD establishes an overarching framework for corporate due diligence, focusing on specific requirements for companies across various sectors. Under the CSDDD, businesses will be expected to implement due diligence measures that are consistent with the OECD guidance for responsible business conduct. In particular, they will be required to integrate due diligence into their policies and risk management systems, identify and assess actual or potential adverse impacts, prevent and mitigate potential adverse impacts, and bring actual adverse impacts to an end and minimizing their extent by using appropriate measures, monitor the effectiveness of their due diligence policy and measures, publicly communicate on due diligence, and provide remediation for actual adverse impacts. Companies that have already implemented due diligence processes within their supply chains will be better positioned to comply with the FLR requirements. The CSDDD applies to both EU and non-EU companies. In the EU, it's applicable to companies with more than 1,000 employees and a net worldwide turnover exceeding €450 million in the previous financial year. For non-EU companies, it's applicable to those that generated a net turnover in the Union of more than €450 million in the financial year preceding the last financial year. This table provides a quick comparison between the Corporate Sustainability Due Diligence Directive and the EU Forced Labor Regulation, in terms of approach, scope, objectives, the targeted operators, the core obligations for companies and enforcement mechanisms. So how can your company prepare for the EU's forced labor regulation? There are 2 key things to consider. Firstly, improve due diligence. You must demonstrate that they have carried out the necessary due diligence regarding high-risk products or those under investigation by relevant authorities. This involves providing evidence of actions taken to identify, prevent, mitigate, or eliminate risks of forced labor within their operations and value chains, an obligation that is already set out in the CSDDD. The focus is therefore put on prevention. The due diligence process should align with applicable EU and national laws, as well as relevant guidelines and recommendations. These may include those issued by the European Commission, the UN, ILO, or OECD. The regulation grants economic operators flexibility in choosing their reference framework, allowing foreign entities to base their due diligence on international standards rather than solely on EU guidelines. Companies are recommended to use the ILO's forced labor indicators to identify, prevent, and mitigate instances of forced labor. Secondly, improve supply chain mapping and transparency. You must also be prepared to provide detailed product-specific information required during investigations, even beyond the initial review phase. This includes details about the products in question, their manufacturers or producers, and their suppliers. Companies must ensure supply chain transparency by documenting all suppliers involved in production and transportation processes.